over 200 plants is really something that the courts aren't always going to sympathize with. And in fact, I think the judge used some of the circumstances from these witnesses to say that in fact the law has its problems, but it's still, you know, good enough. So I guess coming from, you know, the actual case to the testimony to the decision, I understand February 2nd, the judge ruled that Matthew Barron was guilty, I think, of production of cannabis and possession for the purpose of trafficking. I forget exactly, or it was trafficking, either way. But immediately gave him an absolute discharge. An absolute discharge, for those who don't know, essentially means that he walks free, really not much of a criminal record, tagging around. I think at the US border, they just got to ask you if you even use illegal drugs or have ever been charged. And if you refuse to answer, they'll arrest you. If you tell them the honest answer, they'll arrest you. And if you tell them a lie, they'll arrest you. So it's kind of not fun trying to travel across the border once you've been busted. But aside from that, he doesn't really have much of a record. The conviction, though, meant that the law was upheld to be constitutional. And at the same time, though, she said that the, and I say she, I should mention that the trial started out with another judge before Justice Konigsberg took over, and it made the trial that much longer and more awkward. And I think part of the reason that the Crown apparently appealed the decision, I think, may be based on that. But it actually meant that I went to this trial more than any other single person. It was weird. Anyway, she said that the section that made a 1-to-1 ratio and that 3 growers were only allowed in one facility, those 2 sections she ruled were unconstitutional. In line with the Splechopoulos decision and the Hitzig decision, and really set no precedence at all. I think gave the government a year to fix the problem. Now, having recognized that there were charter violations through Section 7 of the Charter of Rights and Freedoms, she apparently, and again, I haven't read or wasn't a witness to the decision, but I'm assuming this is how it was written, that she used Section 1 of the Charter to kind of save the constitutional validity of the MMAR. For those who don't know what the Charter is or how it works, the Charter of Rights and Freedoms in Canada, there's I think essentially 15 sections that are of prime importance. There's probably a lot more than that, I just know the 15. The first one is different than the rest in that the 2 to 15 are sort of trying to spell out what your rights are, right? Not being, arbitrarily prosecuted and discriminated against, and various different, issues. But if a constitutional violation is found to occur with one of these other sections, the court then has what's often referred to as a sober second look at the constitutional validity of the situation. And that gives the Crown an opportunity to argue that there is these problems, but that they're necessary in order to maintain stability. And this is the words of the Crown, page 85, paragraph 240. And this is what they argue. The MMAR and Canada's related drug controls address pressing and substantial objectives concerning the public health and safety of Canadians. The MMAR and related drug controls were designed to address the following legitimate socio concerns: promotion of public health and safety, protection of individuals from the known and unknown harms associated with using marijuana, ensuring the safety and efficacy of any new drug prior to its distribution to the public, respecting the traditional roles of the government as regulator and of the private sector as investigator, manufacturer, and marketer of therapeutic drugs, and compliance with Canada's international treaty obligations. So citing those concerns, the Crown was successful in telling the judge that those constitutional violations are not sufficient to justify giving an acquittal and ruling that the law is truly unconstitutional. So the decision, in that sense, to me, was not the gold standard, I guess, that I mentioned before. It would have been really good if the judge had ruled, for example, on the access argument. And I think that other evidence could have won the judge over. In particular, Senator Pierre-Claude Nolan, one of the experts who testified, and I didn't even have a chance to touch on the expert testimony, but there was some very good testimony that was brought up by experts. Not all persuasive, but it was good. Anyway, Pierre-Claude Nolan believes firmly in people's rights to choose their own medicine, and ended up agreeing with the judge that people should essentially have no more than a diagnosis from a doctor to gain access to cannabis, and that until it was an approved drug, that the doctors didn't know how to prescribe it or what to prescribe, and it should be left to the individual until that point. Ironically, the defense wasn't arguing that position. The defense and the VICS have required a recommendation for their club long before Health Canada started to do that. And so their mandate has been to protect the doctor's right to prescribe. And so for VICS to be saying that anything different than what their mandate suggests would be inconsistent. And I think it would have been really ironic if they would have argued that a diagnosis was sufficient, because that's my mandate, and they've argued against me for using that. So it was quite fascinating to hear the senator and judge agreeing with my mandate and the defense and the Crown saying that that wasn't sufficient. And it would have been in the defense's best interest to make that argument, whether it meant embarrassment or not. So the access argument, I think that there's a lot of room left, because again, the VICS trial didn't argue that the doctor's recommendation was wrong. It argued that naturopaths should be allowed in. My time's running out, so like I say, they lost on all the other issues. I just understood or found out that there has been an appeal in this case, just filed yesterday. It was the due date, and it's very odd. I haven't talked to the lawyer or Tusa or anyone yet, and so my comments need to be limited. But from my understanding, the Department of Justice did not appeal the conviction. Obviously, they can't appeal the conviction. They won. And they're not appealing the absolute discharge or the sentence. So Matt's really quite happy because he's got a discharge. What they're appealing is the remedy that the judge ordered, which apparently was a 1-year fix the MMAR to make it constitutional order. The same order, essentially, that the Ontario Court of Appeal upheld this past fall. I actually quote it in the newsletter. I don't have one here. Apparently, the decision in Ontario telling them to strike this law down has not been appealed to the Supreme Court of Canada. But my understanding is that we're going to hear arguments about whether or not those two sections need to be amended before the Supreme Court, or sorry, the BC Court of Appeal, sometime probably next year. I can't say much more than that. I think I'm going to try to fit in a question though. What's going on?
It's completely off topic, but it's related to cannabis and the law. There's a new law that Harper's trying to pass, C-15 I think it's called, that is very similar to C-26 but with harsher penalties and tied into the new anti-gang laws. Can you tell us anything more about that?
It's C-51, it's Bill C-26, same thing done over again. Yeah, we're going to have to go about it almost the same way, but hopefully the minority government won't be passing it anytime soon. It's a lot of rhetoric. But yeah, we'll be talking about that at 4:20, so thanks. Have a great day, everybody. Thanks for coming out.